Brandon Daniels, no response. Ms. McDaniel says Mr. McDaniels checked in by his. All right. All right, Ms. McGuire, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hand down. Ms. McGuire, what are you requesting?
I'm requesting a transfer to Louisiana because neither of us live in Michigan anymore.
Are you talking about the entire file?
Yes, sir.
You cite the federal rules and a federal code, but there's no state law that allows this. Now, there may be something along the lines of enforcing support orders in another state, but I'm not aware of any transfer of venue under the federal code on a domestic case. Do you have any Michigan law that allows this to happen?
I'm not sure. I'm not sure. My paralegal just told me to say that neither of us lived here, and that we were trying to transfer it. I probably should have done some more research. I'm so sorry.
You don't need to be sorry. I was asking whether or not you had anything that would allow this to happen. Ms. Schultz, there's a mechanism for enforcing support orders in another state, correct?
Correct.
And that's not what's being asked for here. I mean, I'm not asking you to make the motion, but
federal statute that's cited does not apply to registration for custody or support.
Okay. And that's the position of the court as well. If it's enforcing, for instance, a support order, as in child support, that may be different. But in this case, you're asking for the entire file to be transferred. But I'm not aware of any authority allowing that. Now, there is under the court rule under Michigan court rules, a mechanism where you can transfer to another county. And I'm not going to advise you on the law, but certainly you're not even a resident of the state either, according to your testimony.
Yes.
Unfortunately, Ms. McGuire, I have to deny your motion, but I appreciate you filing it, and that's about the best we can do.
Okay. Okay.
Court will prepare the order indicating the motion has been denied. Have a good morning. Thank you. This is Ms. Meyer's motion regarding issues relative to the judgment filed in this matter. Both parties are present. You both please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
So, judgment in this matter was entered on, appears to be around March 19th. And this was prepared by Mr. Whitehead on behalf of Mr. Myers, correct, sir?
Correct.
Okay. Ms. Myers, what is this? First, where's the wrong name?
My middle name is spelled wrong.
Okay. Is it right on the title page?
No, it's not correct on that at all. It's not M-A-R-I-E, it's M-A-R-Y-E apostrophe.
Now, the answer to the complaint indicates that, which is filed. But when the plaintiff, when the plaintiff filed the action, he used M-A-R-I-E.
Yes.
Okay, so I know that there was a proof of service back on June 29th, 2023, which has your middle name correct, M-A-R-Y-E apostrophe, correct?
Yes.
So what you're looking for is to the entire judgment where it has M-A-R-I-E needs to be M-A, however you spell it.
Yes,
apostrophe.
I would like to change my last name. Can't do that with the wrong middle name, I was told, so.
That could be.
Yes.
Okay. Sir, do you have any comment relative to this?
No.
Do you agree that her name is?
Yes.
Okay.
I agree her name is
okay.
How she says
I
it.
just want to make sure. But the record of annulment is even wrong. Is that your fault? Oh my goodness. Motion's granted. I'm not sure how the judgment, we'll certainly modify the case name, but relative to the judgment, we have to have a supplemental judgment of divorce in the file, unless we add an addendum to the judgment. We'll do an order and addendum. We'll add the court sua sponte will prepare an addendum to the judgment of divorce, attach it, indicating you're correct. Any other issues with this judgment?
No.
That's it?
Yeah.
Okay. We'll prepare it accordingly.
Your Honor?
Yes.
I'm sorry to interrupt. I did meet with Ms. Myers earlier this week, and she brought to my attention that the judgment effective date as it relates to child support does not correspond to what was placed on the record. Okay. I did have Ms. McNames verify the recording, and the effective date should have went back to August 10th of 2023, but the uniform support order used March 1st of 2024 as the effective date.
And again, you verified that with Mr. Payne.
Yes,
sir. Do you agree with that?
Yeah.
Sir? Sure. Okay.
So that's what we agreed upon.
All right, well, it's placed on the record. I don't question what's on the record. The record speaks for itself. So we'll have to make that amendment as well. In the uniform support order?
The front of the court will process that. When I had met with Ms. Myers, I had advised her that I thought she would need to file a motion, but if we're here and the parties are willing to stipulate, I
appreciate it. Don't stop shopping. I'll try to make it easy. We'll make the modifications.
All right.
Good luck to both of you. 755 yes. This is the plaintiff's counsel regarding parenting time and other matters. Ms. Oswald is in the courtroom. The court inquired of Mr. Page earlier, and he's not checked in. He's also not checked in via Zoom this morning. Matter scheduled for 9 a.m. Prior to going on to the record, the court inquired of Ms. Oswald whether or not Mr. Page might be appearing this morning, and Ms. Oswald indicated to the court that she has not heard from him since the first of the month. Is that correct?
Yes, sir.
Is that a correct dissertation of our conversation just a few moments ago?
Yes, sir.
Also part of the conversation was the statement by Ms. Oswald that she is to be at work at 10 a.m. this morning and works in Minden City, and the court was going to wait until 10 o'clock to address the matter. However, it is 9:33, and Mr. Page has not checked in with the court, so we are going to proceed in the case. Ms. Oswald's been sworn?
No.
Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Oswald, what is the issue here regarding parenting time?
We had originally spoken about the summertime situation with him having a little one for 2 weeks and myself a week. I've been dealing with severe PTSD issues due to the circumstances that actually brought us into court. He had her for the entirety of Easter and spring break together, so it was almost a week and a half. And when he refused to let me speak with her, I went through extreme PTSD issues to the point my insomnia kicked in really badly, and I did not sleep for 4 days.
Now, he was entitled to the child at that time, correct?
Yes, sir.
Okay.
And I had no problem with him having her. I just wanted to talk with her to be able to, I guess you could say, calm myself. But he was denying any sort of communication between she and I.
How old is the child?
6.
So, is there any talk time provisions?
We haven't had any discussed here in court yet.
Okay. Do you have any proposals?
When she's with him for long periods of time, I would at least like to be able to speak with her at least once or twice if she's with him for more than a week. Like, she and I haven't really been apart except for the 10 days that she was gone in the end of September, beginning of October, which brought us here. And then the longest time frame that she's been gone since then was the spring break and Easter break combined.
And the summer parenting time is he would have 2 weeks with the child, you would 1 week.
Yes, sir. I was wondering if there was any way that we could change it week to week, because I have been having extreme issues with getting Mr. Page to respond as a proper, calm adult on any situation.
Now, are you requesting, let's assume hypothetically the order continues as it has been. You're not requesting a change, just hypothetically speaking. If he has a child 2 weeks, you have 1 week, how many times per week do you want to be able to have contact with the child?
If he has her 2 weeks, I would very much appreciate if I could talk to her at least twice a week.
Twice a week.
Because she and I are always together.
All right, so what days and times would be best for you?
Mondays for sure, and any other day of the week after that.
Okay. Well, since Mr. Page isn't here, do you know his work? I'm not asking you whether or not you know everything about
Oh, no, I can tell you his work
schedule.
style schedule. I'm the one that got him the job start.
Okay.
So he does road construction during the spring, summer, and fall. He literally works anywhere from 6 to 7 days a week, generally only completely off if it's raining.
Okay. So Mondays, and what other day during the week that would you prefer?
Thursday or Friday would be fabulous if possible.
What time for each contact?
I want to say roughly about 6 p.m. if that would be okay, because it's not too late, so she'd still be up, but at the same time, it's not too early to potentially disrupt his entire schedule. I'm hoping he would be home by that time frame because he's usually gone from his place of residence by no later than 4:30, 5 o'clock in the morning, and there's no given time on him getting home at night. That was another reason why I was wondering about the change possibility for, instead of 2 weeks with him in a row, if it would be possible for a week. Because she's not really going to be seeing him as much as should be, if that makes sense.
No, I understand that. Unfortunately, though, when it comes to a parenting time schedule such as that, if a parent decides he or she doesn't even want to have that time period, which to me is a complete crime in and of itself. If you have time with the child, you should be exercising it. The parent can do whatever they wish with the child. You can leave, unfortunately, at a daycare or with Nana or with another family member. They could do that so long as the child is safe. I know that sounds crude, but that's how this works, unless there's some potential harm that could be exhibited or shown relative to the child. But the communication that you're proposing, do you use FaceTime? Do you use
we use the app.
Which one?
The
app post?
Yeah,
that is a video feature.
Yes, sir.
And is that how you communicate with Mr. Page?
Yes, the only time that we communicate outside of the app is if something emergency-wise comes up or like a death in the family or anything of that sort.
Good. Okay. What is this regarding Mr. Page's girlfriend?
I have been receiving random numbers texting me, and I have actually been able to figure out that it is his girlfriend that is sending me these harassing text messages. If you'd like to see just the messages off of one phone number, I have them printed off.
Just give me an example of some of the messages you claim is coming from her.
It's verbally not a good thing to speak of.
I see. Do you wish to have this marked as an exhibit?
Yes, please.
We'll mark it as plaintiff's 1. Please hand those to court administrator. We'll have them marked momentarily. Marked as plaintiff's 1.
With all of the pictures, when you get to the very end, that is the reason I was able to figure out who was sending me the text messages. Because at the very end of all of it, there was a picture of a person's Snapchat taken, and it was then the pictures at the bottom of their screenshot that actually showed me who it was. I don't know if they're going to be clear enough on the print offs.
So these depictions here, you can identify that individual?
Yes, sir. Because of the way that she was speaking and the way that she has verbally attacked me on phone calls previously, the style of speaking combined with the pictures at the bottom, I don't know if you recall, but the last time that we were in here for his contempt of court situation, he had mentioned that he had a newborn. And in the pictures that I had blown up, you can clearly see that his other child is being involved in this in a way, because that's how I honestly figured it all out.
The individual that's depicted, not the child, but the individual depicted what appears to be a darker top. Can you identify who that person is?
I'm trying to see which one you're looking at.
Let me show you what I'm.
So with that, the person that is in the pictures all the way to the right-hand side of that would be his new girlfriend. I can't even give you an actual name of her because he seems to think it's perfectly fine to not let me know who's around my child consistently when he knows exactly who has been around my little one on my end.
So, but how do you know this? Have you ever seen his new girlfriend?
Yes, sir.
Okay, is that the same person?
Yes, sir.
Okay, so you are identifying.
I just can't give you a name or anything because I do not know.
What about the switch games?
He has yet to return them. She had taken them down, I want to say either towards the end of November, beginning of December, after you guys had stated that whatever she takes down, she brings back home. And he has yet to return them. He's been, and I don't know for sure, but I do believe it's in the paperwork that I had turned into Mitch, the last time that I had handed in conversations about there's been multiple times where I've asked him, can you please return this on this date? Can you please return this on this date? And he continuously says, well, now that you get child support, you don't need to have it sent back to you. You can just go buy a new one.
So other than the switch game, and I'm assuming there are components with that.
I thankfully have the switch system. I have the controllers. I have the charger port. I just do not have any of her games.
What else are you requesting to be returned?
As of right now, those are the only things that she and I can find that are missing.
No other clothing that she brought with her that she intended to bring back?
Just gotchis.
Anything from the front of the court in this file? I believe we also have another hearing scheduled at the end of the month.
Hmm?
Or am I thinking of another file?
No, that's
Okay, disregard. I'm incorrect on that. I'll take responsibility. Okay, well, the issue though is you're requesting the parenting time that's originally ordered to be modified, and there has to be proper cause or a change in circumstance. It's probable cause standard, more likely than not, is what has to be shown. What has been alleged is that since one extended period of time, including the Easter holiday and the spring break portion, the child was with father for longer than a week. Mm. Mother complains of having PTSD issues relative to that. Also, she is alleging items that are being sent out are not being returned, including the switch games, and there are allegations regarding the defendant's girlfriend that that she is messaging the plaintiff in this matter. Parties have joint legal custody, though, correct?
Right.
Okay. There's an issue regarding the haircut as well. I forgot to mention that.
My daughter had not had a haircut in her entire life. When she went down to her father's over Easter break, when she came back, her braids were significantly shorter. He chose to completely ignore me when I was just trying to find out information. Had he at least let me know something or asked, hey, is it cool if I do this? I would have had no issues. But with the factor being that I literally had to ask his sister, who is the beautician that cut her hair, if it was the situation that had happened, it's frustrating to say the least, because I did not have any plans to have my daughter's haircut in any way, shape, or form until she chose it.
Did you file a complaint with the friend of the court relative to the hair issue?
I don't believe so.
Okay. Then I'm assuming then a show cause here at this schedule.
The friend of the court, well, we do have authority to get involved in those types of decisions. We generally will decline to the parties and bring that action to the court.
Okay, fair enough. Fair enough. I'm not trying to pass the buck either, but I just want to make sure I have everything correct here. Problem is Mr. Page is not here. He was properly served in this matter. So you're stating with joint legal custody, you're supposed to communicate with each other relative to this, and he didn't communicate, and you're stating on the record, under oath, that your child's hair was cut without your permission.
Yes, sir.
Okay. Very well. Going to order a fine, Mr. Page, amount of $100, violation of court orders relative to joint legal custody. That'll be due and payable by May 31, 2024. Relative to the property that's has allegedly not been returned, the court will order that he is to return the property back, specifically the switch games and any underwear, correct?
Yes, sir.
Of the child that was brought to the parenting time and expected to be returned. That will also need to be done. I'll make it at the same time, May 31st. By 4 p.m. Relative to the parenting time issue in this case, I don't find any proper cause or change in circumstance. However, the court is going to order in this matter that mother is awarded video time or communication with the child during father's parenting time 2 times per week on Mondays at 6 p.m. and Thursdays at 6 p.m. If Thursday doesn't work, then it will be Friday at 6 p.m. by the app close program or app. But changing the summertime parenting time in this matter, again, unfortunately, I don't find a proper cause of change in circumstance.
I understand that. Is there any way for us to enforce the factor that he has yet to get her allergy meds?
Did you bring that up in the motion?
I had forgotten about that.
I can't order it because it's not brought before the court, but I'm going to strongly, if he's watching, I'm going to strongly encourage the defendant to make sure that all medications are provided as prescribed and returned properly when the parenting time is over.
And the beautiful thing is, if he doesn't want to return them, he can pick them up over the counter.
You can do that as well. All right. I wish you the best, miss. You're all set.
Thank you.
Thank you. Off the record. Hopefully you get to work somewhat on time.
At least it's not going to be too late. I appreciate it.
Regarding custody, she's present in the courtroom. Court calls Kenneth D. Nowitzki III. Kenneth D. Nowitzki III, no response. Ms. McDaniel says, has that individual checked in via Zoom this morning?
Not at all.
Not at all. Okay. Matter is scheduled for 9 a.m. The court did inquire off the record a moment ago, Ms. Moore, of whether or not Mr. Nowitzki was coming to the hearing, and she's not aware that he would be or had any idea where he even is. Is that a fair statement?
Okay.
All right. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Ms. Moore, what is the custody order currently in place?
Well, I thought it was suspended, right? Because my son was here, I'm pretty sure you said it was suspended, right? I went to the clerk's office, the beginning of last month or this month, before I filed, and they told me that it was supposed to be every other weekend. So I was a little confused on that.
Okay. You have joint legal custody regarding the minor child with Mr. Nowitzki?
Yes.
But you have primary physical?
Yes. But like, because the last time we were here, he never showed it. So we were suspending his rights in October, I believe.
October of last year?
Yes.
Anything on the file? Anything in front of the
Your Honor, the friends of the court's understanding is that legal custody has not been established by court order.
Okay.
Ms. Moore is granted sole physical custody, and the court did suspend Mr. Nowitzki's parenting time on November 7th, 2022, and parenting time is suspended until he files a petition for us.
Well,
I mean, because the court told me that it was every other weekend, so I was really confused on that. That's why I'm here.
I don't see a copy of that order in the file. Last thing I see in the file, there was a support enforcement order December 1, 2022, and then after that is a notice support enforcement order discharging bench warrant December 20th, 22, and then moving into 23. Next thing is an income withholding for support order, November 22nd. I'm not sure why the order is in the file. I'm sorry. I don't know why that is the case, but if the friend of the court states that parenting time was suspended, it's suspended, period.
Yeah, because, well, the reason why I'm here today is because he recently just got arrested again for domestic violence. So my kid is honestly not safe in his hands. And when I found out that it was every other weekend, that's why I was like, it can't happen.
So you already have primary physical custody. In your motion for custody, and it's not clear to me, but are you requesting you have sole legal?
Well, I was going to until he has to sign off for that, and he's not gonna sign off. But
he's entitled to be here this morning to address it, but you're requesting, when you filed your motion for custody, I'm sorry?
I don't want my son over there right now.
Well, that's already ordered. And we'll prepare a supplemental order to be placed in the file to indicate that. But your motion for custody refers to the allegations of being arrested, of the defendant being arrested, and it's the best interest of the child involved to have custody changed to full custody.
Yes.
So if there is no legal custody, is that what you're asking for?
Yes.
Do you feel that having sole legal custody is in the best interest of the minor child?
I do. He's honestly not changing. I tried for 5 years to not take the child away from his father, but he's just getting worse. He's in and out of jail, not showing up on time. I have to constantly take him over to his house, or else he will not get his kids.
Okay. All right, at this point, on an interim basis, mother is awarded sole legal custody, and physical custody will remain as previously ordered. Parenting time is suspended. It was previously suspended, however, the court order is not in the file, and I'm not sure why, but I will follow through with that. If father wishes to challenge legal custody, he can file a motion to address it and or the parenting time, which I believe I probably would have stated when the order for parenting time suspension occurred last. Regarding you having sole legal and you currently have physical custody of the minor child, the court will still order the domicile provision where the minor child's domicile shall not be removed from the state of Michigan or more than 100 miles from the child's current residence. So all that simply means is normally when someone has sole legal and has primary physical, you can pretty much move wherever you wish, but I want to keep it currently within the state of Michigan and within 100 miles of the child's current domicile. And if he wishes to challenge that down the road, he needs to file a motion. Fair?
Yes.
Ms. Schultz, is there anything the court's missing?
Yeah. Unless the court wishes to have the issue of child support addressed, but if we're looking at a possible period of incarceration, it may be possibly.
Would you agree? I would agree as well. Suspended, period. He's not to have the child. If he wants the child, he can ask the court. 5, 6, you're all set.
Thank you.
You're welcome to plaintiff's motion regarding custody and parenting time. Miss, your name is Patricia M. Capley.
Yes.
You are the plaintiff. You appear in the courtroom this morning. Sir, you are John D. Patterson II?
Yes, sir.
And you appear via Zoom this morning. Will you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
I do.
Thank you. You may put your hands down. Before we proceed, I'd like to hear from the friend of the court regarding the orders previously filed. Mr. Holman.
Currently, Your Honor, the party shares joint legal custody with Ms. Capling having physical custody of the minor child. Parenting time is alternate weekends during the school year, and the parties submit proposed or agreed upon summer schedules to the front of the court office. They've been doing that for the last 2 years, and they've already submitted that for this upcoming summer, but during the school year, every other weekend, and then summers vary year to year, depending on their agreement.
Okay. Thank you, sir. Appreciate it. All right, Ms. Capley, what are you requesting, please?
Full custody.
Okay, you have physical.
Yep.
And what do you mean by full custody?
Where previous on April 21st, we met up at Lucky's and
Okay, we'll get to that in a bit, though. There are two types of custody in Michigan. There's physical and legal custody.
Yeah.
You already have physical custody, so what are you asking for?
For
For
full
custody. Full what?
physical.
Full, you already have full physical.
Well,
I want to make sure, I can't put words in your mouth.
a full custody.
There,
Like
there are two types.
where he is, I don't want to, full custody until he gets help. That's
Okay.
what I'm, because
Okay, just hear me for just a second. There's physical custody in the state of Michigan.
yes,
That means where the child resides primarily.
yes, that's where my child is with me.
Right, so you have that.
Yes,
There's also legal custody. And legal custody deals with decision-making on behalf of the child. It could be.
yes, I would want that also.
Okay, so you're asking for legal custody then too, sole
Yeah.
legal. And why are you requesting sole legal custody?
Because on Sunday, April 21st, we were meeting up at Lucky's for our our meetup places. And
Lucky's where?
on a steakhouse in Emily City.
Okay, that'd be Lapeer County. Right near I-69.
Yeah,
Court can take judicial notice that that's Lapeer County. And what are you alleging that happened?
domestic violence, he got, kind of kidnapping because after.
Kind of kidnapping.
Well, he took my child because he got triggered and hit my fiance's truck like 5 or 6 times. And then he hit me and I was blocking him. I have evidence. He does have a child abuse case against him, against his daughter. And he's a repeater.
Okay, let's back up. On April 21, you met at Lucky's. Was that to be an exchange of the child?
Yeah, it was an exchange for me to pick my son.
Okay, so you're supposed to pick your son
Yeah.
up. Did that happen?
Well, afterwards, after the cops got involved and
police were involved.
the domestic was involved.
Okay. So police were called and you allege that he struck you?
He struck me, he struck the vehicle that I was in because he was triggered. Because I didn't give him a chance of dating me again and he knew I was with my fiance.
And you claim that there's a child abuse
Yes.
matter involving Mr. Patterson as well in another?
Yes, on his daughter. And I have evidence to show.
What's the allegation?
Not domestic, but child abuse. There's,
Are you aware of criminal charges being brought?
I would think so. I mean,
Okay, you're not certain, but what about on April 21st? Are there criminal charges pending against Mr. Patterson?
the cop did a domestic report for me and he said it was domestic violence.
Okay.
I don't know if there's charges.
Have you been notified by the prosecuting attorney's office in Lapeer County?
No,
But police were notified.
police were notified.
And after the police were notified, what happened with the defendant?
He got arrested
He was arrested. Okay.
and they raided his truck or SUV.
Have you had the child since?
Yep. Well, he had him the previous weekend. Supposedly my son went out of state on my permission also, so.
Tell me the child did not, obviously there's an exchange. I'm hoping the child did not witness this.
Yes, he did.
The child did witness this.
Yes, all of it.
Anything else?
Just, he needs help and he knows it.
Mr. Patterson, before we proceed in me asking you questions in this matter, I have to ask, are there criminal charges pending?
There are criminal charges, but I would like to explain my side of the story before anything is.
Oh, okay, before you do that though, Could you tell me what the charges are?
DMV, and then malicious destruction of property under $200.
And what do you mean by DMV?
Domestic violence.
Are there
Because
any felonies? Are there any
there's
felonies?
no felony charges, no. Not that I'm aware of. I mean, I haven't talked to my lawyer yet. I have court on the 17th.
Okay. The court has the opportunity under the My Court application to look up this matter just to see what the charges are. Do you have any objection to me looking at that very briefly?
No, I mean, I'm not hiding anything from you. I've never really.
I'm not asking you to hide anything. I just
no. I'm just.
Yeah. Have some sort of.
I mean,
you don't have
right
any
now.
objection?
No, I don't have any objections.
Okay. You've been before a judge?
Yes, we rescheduled it. I went on the 10th, May 10th, in front of a judge, and then she scheduled it to the 17th for May 17th.
Okay. So she would be Judge Shager Barnard, I believe.
I believe so, yes.
Okay. Any objection to me just looking up and see what the pending charges may be?
Yeah.
Okay. You do have an objection or you don't?
No, I don't.
Okay. I just want to have a clear record. And I have the permission of both parties. This I shall.
I think there might be a CCW charge or something for a pistol. They said I was transporting incorrectly, so that might be on there too.
Let's take a look. Scheduled for a probable cause conference on May 17th, as stated by Mr. Patterson. All right, the charges include carrying a concealed weapon, domestic violence, malicious destruction of personal property less than $200. Bond was set at $2,500. All right, so Mr. Patterson, you just stated a moment ago that you wish to give your side or account of this. I have to caution you. There's a criminal case pending. You have the right to remain silent. Your silence cannot be used against you. Anything you say in this courtroom could be used against you in another proceeding. You don't have an attorney representing you in this matter. You did state you have an attorney representing you in the criminal proceedings. So I have to caution you, if you do respond to this, however you respond, the prosecuting attorney in Lapeer County could use that information in your criminal proceeding. Do you understand that, sir?
I mean, I understand that, sir. And everything I'm going to tell you is the same thing I put in the police report, and that is on record when I called 911 to state the matter at hand.
Okay, well, I just wanted on the record that this court didn't force you to say anything, and the court did advise you regarding your rights. Do you acknowledge your rights and understand them?
I do acknowledge them, yes, sir.
Is there anything affecting your mind or brain making it difficult to make important decisions?
The safety of my child.
Okay, well, if you wish to respond, that's up to you, sir. Go ahead.
So to respond, I know Ms. Capling had reported or had sent in a letter stating the issues. There's some cliff notes. There is a couple lies, but I did not react because Ms. Capling did not inform me that she was back with her ex-abusive girlfriend or fiance. So leading back to November 26th, when me and Ms. Capling was co-parenting, there was an incident to where her fiance tried to run my son and her off the road. When dealing with the situation, I told them to call the police. I have a text message from my son stating that she had told him not to call the police. And this is versus Margaret Parks, which...
Can you spell the last name?
Huh?
Can you spell the last name of that individual?
Parks, P-A-R-K-S.
Okay. All right, go ahead. I'm sorry.
So going from that, Ms. Capling knew how I felt about this person. Not once have she communicated that they were back together or doing anything. My son had asked her and talked to her to inform me, and she told him to shut up. When coming to pick him up, she did not clarify who was coming down with her to pick her up. So on that day, when we pulled into Lucky's and I saw the vehicle, I asked my son, did he want to go with her? He said no. So I got out of my truck. Patty got out of the vehicle, and I told Patty I was refusing to release custody to her at this moment because of the situation that happened November 26th with her fiance trying to run my son and her off the road.
Okay, time out. November 22nd, 2023?
November 26th, 2023, correct.
26th, 2023. Okay. Now, regarding that allegation, did you contact police?
I dialed 911. I was on the phone with dispatch, and Ms. Capling was on the phone with dispatch also.
All right.
There is record of it.
Understand that, but did the police perform any action upon your allegations?
I haven't heard anything, nor did she say that the charges were dropped or anything. The only thing I knew was at that particular time they were not supposed to have contact.
Okay, so that happened in November of 2023. When did you even file a motion to exclude this individual from being around the child?
I mean, at that time, no, because me and Miss Capling were co-parenting. So okay. Miss Parks wasn't supposed to be in the picture, and I didn't know Miss Parks was ever back in the picture because because of the situation, I was frustrated and upset, and I removed myself coming up to Bad Axe because of that happening. That was my last straw with that situation.
Okay. So moving forward, though, when you discovered apparently that this Ms. Parks was involved, I mean, again, I'm not trying to pry this out of you because there's a criminal charge pending, but do you wish to respond to those allegations of allegedly ramming a...
So when I told Ms. Capling that I was refusing to release Tristan in her custody, she got outraged. And because she got upset, I got upset. And that's when I started yelling about the fact that she literally tried to run you two off the road and you are back with her. Like, Ms. Capling never communicated anything. She never communicated. She said she was with someone. Yes, that is correct. But she never said who that person was. I didn't know who that person was until the day of doing the drop-off at Lucky's.
How old is the child?
12.
Well, and you would agree as well that the child had seen all of this?
He was in the vehicle, correct? Yes.
Anything else you wish to place on the record?
I did not kidnap my son. I refused parenting to release her for parenting. And after the incident, I left. I called 911, and then we were coming back because they wanted me to do a statement, and that's when I got detained. So you called police as well that day? Yep, there was 3 witnesses. A landscaper called, and then Miss Parks called, and then I called also to report the incident.
All right. Your final response?
Previous, she did try to run me off the road, but she has no police report on it. She has no criminal charges against her, against me.
Was the child in the car?
Yeah, yes.
This is your
It was on Church Road, and then she was trying to get past me, so I had to move over. So she was, I would say, not outraged, but I brake checked her, and she was going. I was almost again by the stop sign.
Is the child in the car?
And my car, yes. So I moved over.
Time out. So why was she following you?
Good question. But it's a dirt road. We didn't have no PPO. We didn't, I mean, you could be looking at a sunset for all I care. But I was right by a stop sign. So why go against a stop sign and go left?
But you stated under oath that you brake checked her.
Yeah, to make her stop because she was going down a dirt road fast.
What would happen if she didn't notice that and you were rear-ended with a child in the car?
I mean, he did have his seatbelt on, but I wasn't gonna, you know, I had enough room at the stop sign where she could go over.
Okay, so.
But she's had counseling, she has, therapy once a week.
You're talking about the child?
No.
This individual?
Yeah, my fiance.
Okay.
And she's changed.
Well, what about?
But that doesn't make him to put his hands on me.
That I understand, but that's an allegation yet. It's not been proven. I understand what the allegation is. What are you proposing then regarding parenting time for Mr. Patterson?
He needs help. He's a repeater. Child abuse. He has CPS cases on against him.
When?
This pending charge. I don't know exactly what his other his daughter's cases, but I have evidence that witness has a child abuse against him. And then now me. There's no charges against Maggie or Margaret Brooks.
Dan, do you have any response to the allegation that there were CPS investigations involving you and another child?
So about 2 years ago, I spanked my child for stealing. The way I went about spanking it, I left a dime-sized bruise on her hip. So when doing with the case, I got hit with 4th-degree attempted child abuse. I went through counseling, I did CPS, I had therapy, and I was cleared of everything. And I went to jail for 7 days.
Okay. Is that the last contact with Child Protective Services?
Yeah, I haven't had a contact with Child Protective Services in over 2.5 years.
Okay. I'm assuming there's a no contact provision between, you are not to have any contact directly or indirectly with Ms. Capling while this matter is pending?
But I would like to also state that she filed this motion, but at the same time, she has been contacting me through app close for changing weekends with Tristan. So her filing this motion is really confusing on why she filed it. She filed it on the 29th, which I understand, but twice through me and through my son, she asked me if we were swapping weekends. She wanted to swap the 17th, and it's in app close. The first part of it is in app close. The second part of it is in my son's phone. And my response to her was, my response to my son, because I wasn't going to respond in app close because I'm not supposed to have contact, but I couldn't answer any of her questions until after May 10th because we were coming to this hearing.
I see.
So if she's...
Yes.
Just a second. I'm sorry. He didn't finish.
Sorry.
I apologize. Mr. Patterson,
so if she wants to take parenting time away from me, because that's what she's filing for is parenting time, then why are you still trying to change or swap weekends if you're taking me to court for parenting time? Now, mind you, Ms. Capling does not communicate when it's best for our child. She only communicates when it's best for her. The safety of our child has been in question, and she doesn't realize that. She also won't tell you that her ex or her fiance has been abusive to her, have kicked her and my son out of the house and apartment numerous times, and my son is scared for his life to be with that woman.
You're referring to Miss Parks?
Correct.
Okay. Your final comment.
Okay.
I said final a couple times, but the picture is expanding.
I try to contact his stepmom down in where he lives, or supposedly lives. She said, ask John about the meet time for last weekend. And she's like, ask John. I was like, I can't contact him. And she's like, well, do it through the app. So I did. I was like, when are we meeting up? Because I didn't know what the meet place was. Yeah, Tristan said it was at the police department, but do I know physically? No. I would have met at Lucky's where it stated. It's in 5. So,
go ahead.
And I asked him, where's our meetup spot? Because he's the only one that knows. I don't. So yeah, I did contact him through the app close though. And then previously I said like a month ago, hey, are we doing May 17th through the 19th? And you will get the 24th through this 27th because he has football practice. And then that's when he said, or Tristan said, he can't contact you.
So alternate weekends currently.
Yeah,
where's the pickup and drop off place supposedly?
Lucky Steakhouse.
Okay, and you don't want that to change, right?
No, I mean, it can change if he's gonna put his hands on me.
Well, I understand that, but I just want to make sure we have the prior order.
Yes, Lucky Steakhouse.
Alternate weekends.
And he gets most of the summer, and then between Father's Day weekend he gets some, and then July he gets some, and then I get them like first part of August, like the maybe 10 days, or we switch.
Okay.
But no, I don't want to take his son away from him.
The alleged brake checking incident, was that back in November again?
Yes.
I want to make sure, November 23rd. Okay. All right, court's heard enough. I'm ready to issue a ruling.
Did you want to see?
I still have some stuff to say, Your Honor, sorry.
You do?
Yes.
Just a moment. What do you have there?
Pictures.
Pictures of?
Myself with the bruises and his daughter.
His daughter?
Yes.
What's depicted regarding his daughter?
Abuse.
From when?
Whatever that.
2 years ago?
Yeah.
Court will take judicial notice of that. You're all set. I don't need to look at it. Court will take judicial notice. Mr. Patterson, you have something else to say.
Yes. So 2 things. Everything that she has asked for is on court. The judge, when I got out, asked me if I still had parenting time, and I said yes. They changed it and said the new meetup and drop off is at Imlay City. I didn't decide that, the judge decided that. Ms. Capelin is the one that's making the allegations against me. She's the one that needs to do her due diligence and find out from the courts what is going on with the case that she is stating against me. So that's number 1. Number 2 is in app close. So the motion was filed, what, April 29th or 24th for the motion for custody? Okay, correct. In app close, May 1st. Are we switching May 17th through the 19th for May 24th to the 27th? So this is after the fact that she already filed the motion. I would assume so, right? Because April and now in May, this is an app close. This information is in app close. And then on So then on May 5th, she texted my son asking the same question, which my response to that was, I can't answer any questions until May 10th.
Okay. Picture is getting wider and wider. I thought I saw Mr. Holden's statement.
Just putting on the record, Your Honor, that the order from May of 2021 from this court is that exchanges are at Lucky Steakhouse in Emily City. So I'm not sure where the confusion was that it'd be someplace else, because it's been court ordered for 3 years now. Be Lucky Steakhouse.
Okay. So I have the information. I was ready to make a ruling, but all I'm hearing though from you, Ms. Capling, is that he needs help. What are you asking for regarding his parenting time?
I want the safety of my child. I don't want it to happen to his other child, the abuse. Because it's already against his daughter. It's already against me.
Right, but again, we're talking 2 years ago though regarding his daughter, right?
He's a repeater.
No, Miss, you are alleging that he abused another child, and it was 2 years ago. I just want to make sure we have that clear.
Yes.
Okay.
I'm
not passing judgment relative to what may have allegedly occurred at Lucky Steakhouse. That's for
he beat her.
There are criminal charges brought, so I'm not questioning that. It'll be up to the court of law to decide how that moves forward. But this is what the court is going to do. There must be either proper cause or change in circumstance in a review of the custody factors to determine whether or not custody should be changed. That standard is a preponderance of the evidence standard. And what is alleged here is alleged domestic violence, as well as there was a concealed weapons charge, and there's also malicious destruction of personal property. Criminal charges have been brought in Lapeer County against Mr. Patterson in this matter. How that case proceeds is how that case proceeds, but the allegations are there. Both parties state under oath that the child was present at the time. And what I'm hearing from Mr. Patterson is the behaviors that are alleged here. And again, he's not claiming the domestic violence or anything like that. What he is saying, though, is a trigger was this Ms. Margaret Parks, who the plaintiff also acknowledges back in November of 2023, Ms. Parks was involved with Ms. Capling relative to an automobile incident on Church Road, where even plaintiff states she had brake checked this Margaret Parks. And as a result, and the child was in the car at the time. Now, according to the plaintiff claims that Ms. Parks has changed. Now they are engaged to be married.
We're getting a house together.
Just a moment. You've had your opportunity. And so I find, based upon preponderance of the evidence standard, that there is a change in circumstance for two reasons. Number one, the allegations of domestic assault made by the plaintiff against the defendant. That's one of the factors, child custody order, child custody factors the court has to consider. The child was present at the time, so clearly that's an issue. Number two is this may have been, I state that in quotes, may have been triggered based upon an allegation that is acknowledged by the plaintiff of an incident involving Ms. Parks. Now, the court will order a friend of the court investigation relative to custody, parenting time, and support from the date, and support would be reviewed from the date the motion was filed. Also, as we move forward in this case, while the matter is pending, the court did not hear any evidence that the defendant is under investigation regarding any child abuse recently. Now, there's an allegation approximately 2 years ago, and I'm not doubting that because the defendant acknowledges that he was contacted by CPS. He even served some jail time as a result of it. Now, I don't deny that. So that portion is there, but there's another reason the court is ordering a review of the custody matter as well. It's also alleged that Ms. Parks was involved in an incident with the plaintiff whereby the child was in the vehicle that could have caused the child harm. That's another factor and reason the court has finds proper cause. It's been acknowledged by the plaintiff in this case. On an interim basis, the court will order that prior orders will continue regarding parenting time. The court will not disturb the bond condition that has been set by the Honorable Laura Shager Barnard in the Lapeer County District Court. If she states that it's to be in Lapeer, I'm sorry, in Imlay City, it's going to be in Imlay City, and the prior order indicates that it's at Lucky Steakhouse, which coincidentally is in Imlay City. So that's going to continue. However, one modification, and I know this stings, but I'm very concerned regarding the interest of the child. Ms. Margaret Parks is off limits to be around the child in any way, shape, or form while this matter is pending. So Ms. Parks is not to be around the child. Ms. Parks is not to have any contact with the child while the matter is pending. And that's the order of the court. Prior orders remain in effect.
Okay, and it's at Imlay City Police Department, Your Honor. That's where they work. Imlay City Police Department.
That's where you're meeting now?
Correct.
All right. Is that correct, Miss? You're meeting at the Imlay City Police Department?
Last weekend, yeah, because I didn't know where, because I was meeting at Lucky Steakhouse.
No, I can understand that. Do you have any problem with it being at the Imlay City Police Department?
No.
Okay.
But my child has been around Maggie all his life. Since he was born. Was he? No.
I understand that, but I'm looking at what's happened recently.
But she's changed.
The court order will be modified that the parent pickup and drop off will no longer be at Lucky Steakhouse, will be at the Imlay City Police Department. Prior orders will remain in effect as otherwise stated. Now, next thing is both parents will be have to fill out questionnaire forms and information regarding custody and parenting time. Make sure you get those forms filled out. Make sure you get them to the front of the court so that they can make a recommendation. Just you raise your hand.
There is no charges against Maggie, so why can't my son be around her?
I've made my ruling.
Okay.
I made my ruling. I'm looking out for the safety of the child. That'll conclude the proceedings. Thank you. Off the record.